Yeah, good evening. Can you hear me? Yep, good, great, thank you. My name is Professor Jerry Redmond. I'm the Dean Research at the College of Business, Government and Law at Flinders University, and I'm going to be your host for this evening. Let me start off by acknowledging that we're meeting on the traditional country of the Ghana people of the Adelaide Plains and pay respect to their elders, past and present. I recognize their respect and respect their cultural heritage, beliefs, and relationship with the land. And I acknowledge that they are of continuing importance to the Ghana people living today. Now, before we commence the evening as well, I'd like to point out some housekeeping details about emergency exits, okay? Emergency exits are located outside of these doors through the glass sliding doors and turn right down the stairwell, okay? And then you go out to Victoria Square where the meeting point is. You all gather there and be counted. Toilet facilities can be accessed also through the doors over there, the glass sliding doors, and turn left down the hallway, okay? Now, you're most welcome here this evening, and I'd like to thank you for joining Flinders for this lecture series entitled Brave. If you wish to share this event with your peers, make sure to hashtag Brave Research in your posts and tweets, okay? Now, Brave is not just a reflection of the extraordinary research that Flinders University pursues today. It's a call to action that harks back to the earliest days of the university. The university is just over 50 years old now. As we at Flinders make inroads in our mission to change lives and to change the world, we are focused on making a difference by extending the boundaries of knowledge, by addressing big challenges, and by changing lives for the better through our research. I think we'll have an excellent example of that this evening. Our founding Vice-Chancellor, Professor Peter Carmel, explained his ambitions for Flinders in the now famous quote, "We want to experiment and experiment bravely." It's a concept that has captured the imagination of successive generations of Flinders researchers and continues to inspire us today. This bravery is evident in our researchers and in the research discoveries that we are sharing with the world for the greater good. And tonight, we'll discuss a true crime story of wrongful murder conviction in South Australia and the fight for human rights and the freedom of a person who was wrongly convicted. In recent years, the USA has had over 2,000 exonerations, some 350 based on DNA. In the UK, the Criminal Cases Review Commission has helped overturn over 440 convictions, including 4 in which people had been hanged. Innocence Canada has helped exonerate 25 people wrongly convicted in that country. Major reports in each of these countries have identified prosecutorial misconduct, faulty expert evidence, police misconduct, and judicial error leading to corrective actions. Now tonight, Associate Professor Bibi is going to discuss research undertaken to overturn criminal convictions here in South Australia. Bibi is an associate professor in the College of Business, Government and Law at Flinders University. While her academic interests span contract, commercial, and corporate law, she has also gained recognition for her work on miscarriages of justice and related issues. She trained at Middlesex University and the London School of Economics and has practiced law in the UK, in Malaysia, and here in Australia. In a minute, Bibi will commence the lecture that we've all been waiting for. And this will be followed by a panel discussion among experts in the field, where we'll be able to discuss particular questions that members in the audience have put forward already. But without further ado, please welcome Associate Professor Bibi Sangha.
I would like to welcome all of you here this evening. Our discussion today is to ensure that all members of the community have an opportunity to understand how our legal system can sometimes fail to achieve the goals of justice and a fair go for all. I should mention that various members of our distinguished panel will be able to address issues that I'm unable to cover in my brief introductory comments. Mr. Sam Abbott, QC, first introduced us to Mr. Keogh's case when he was working as a solicitor. He thought that we might be able to assist with some background information, or research rather. Little did we know then what he was leading us into. He resumed his involvement some years later when he was, with Mrs. Marie Shaw, QC, able to bring Mr. Keogh's case to a successful conclusion. He can obviously speak about the legal issues. Professor Tony Thomas has worked extensively on this case over many years. His involvement with what became known as the baby deaths cases was also a significant factor in our evaluation of Mr. Keogh's conviction. He can speak about the baby deaths and the issues relating to forensic pathology. Mr. Graham Archer, as the executive producer of Channel 7's Today Tonight program, managed to maintain his network's support for what must have been a record number of programs on miscarriages of justice in Australia. Those programs helped us to establish this new further right of appeal, without which Mr. Keogh would still be in prison. The role of the media in wrongfully convicted cases is frequently misunderstood. Finally, Dr. Bob Moles, through networked knowledge, has been our coordinator, my co-researcher, my co-author, and a sometime prison visitor. He can explain why we decided to make Mr. Keogh's case a leading focus of our research. I would also especially like to welcome Mr. Kiyo, who is in our audience. It is, after all, his case which is the focus of our attention this evening when we speak about the unmaking of a murder. He was convicted in 1995 for the murder of his fiancée. It was alleged that he had forcibly drowned her in the bath at the home that they shared in Adelaide. If that murder had occurred, as alleged by the Crown, and if Mr. Keogh had been responsible for it, then it would of course have amounted to a dreadful crime. It is a common feature of a significant number of miscarriages of justice that they do involve the worst of crimes. In some cases, there is no doubt that a terrible crime has occurred. When Deborah Leach was found dead on Teparoo Beach in Adelaide in the early 1970s, there was absolutely no doubt that she had been murdered. But the obvious question was, who did it? We can understand the public alarm, the pressure upon the police, upon the forensic services to reassure us, the public, that the matter is under control. When it is reported that a person has been charged, the sense of public relief is palpable, if perhaps premature. There is a feeling that order is being restored. Everyone is doing their job, and the threat to our sense of well-being is removed. At that stage, of course, we may have forgotten about the presumption of innocence and the seemingly technical issues about proof beyond reasonable doubt. We may not wait for the jury's verdict before determining that the accused person is worthy of our condemnation and should be subjected to the severest punishment that the law allows. By the time the jury delivers its verdict, we can be confident that the police, the forensic services, the prosecutors, the lawyers, the judges have all done their duty. Our collective sense of anger and disgust is only partially satisfied by learning of the lengthy sentence that will be given for that person to serve. What then are we to make of those who may appear years later and attempt to raise doubts about the guilt of those convicted? Quite an understandable response might be to say that we don't think much of them, and we don't think much of what they're trying to do. It is clearly wrong to cause further pain to the family and friends of the deceased person. But what if we have got it wrong? If the wrong person has been convicted of a terrible crime, then don't we have two sets of families and two sets of victims to think about? One is the victim of a terrible crime, and the other is a victim of the failed justice system. This is a point well made by the Honourable Michael Kirby, the former Justice of the High Court, in his foreword, which he wrote to each of our last two books. He took the opportunity to discuss at length his involvement in the appeal of Mr. Mallard, who had been convicted of the murder of a woman who had been working in her shop in Perth. He sat on Mr. Mallard's first appeal to the High Court, which was refused. He sat again on his second further appeal some 10 years later, and this time it was unanimously overturned. The conviction was overturned. Mr. Kirby expressed his deep personal regret that an obviously innocent person was required to spend so much time in prison in circumstances where the prosecution had withheld evidence which contradicted a significant part of their case at trial. We think there are some parallels between the cases of Mr. Mallard and that of Mr. Keogh. In both cases, the evidence presented at trial was manifestly defective, and the Crown had known that. In both cases, the Crown resisted further reviews of the case. After the convictions were overturned, the Crown continued to claim there was evidence of guilt without proceeding with a further trial, which would have allowed those claims to be tested. We echo the words of Mr. Kirby when we say that it surely cannot be any solace to the family of the victim of a terrible crime to know that the wrong person has been imprisoned for it. Think of it, if you will, about the IRA bombers in the UK in the 1970s. On the night the bomb went off, 10 people were killed in one pub bombing and 11 in another, with 220 people injured, some very seriously. The worst possible bombing atrocity in the UK since the end of the Second World War. Those subsequently accused of those terrible crimes appeared in court, showing signs that they had been beaten, and the public response was one of general satisfaction. It took 17 years to establish that they had been wrongly convicted. In the meantime, they had been beaten and tortured by police, prison guards, and other prisoners. Paddy Hill of the Birmingham Six spoke strongly about it when he visited Adelaide some years ago. He still does. He still gets very, very upset. The appeal court eventually accepted that the forensic evidence given at their trial was not only wrong, but was actually fraudulent. The expert witnesses, it seemed, were so keen to assist the prosecutors that they deliberately gave false and misleading evidence to secure their convictions. Edward Splatt was said to have raped and murdered an elderly woman at her home in Adelaide. He was convicted entirely on circumstantial evidence, trace evidence involving paint, wood, foam and bird seed particles. His trial lasted a mere 11 days, but the Royal Commission that followed took 196 days, after which it was established that all of the 20 or so experts who had given evidence at his trial had all made mistakes in their evidence. You might ask, how is that possible? How can 20 experts all make mistakes, and why would all those mistakes favor the prosecution case? Expert evidence has to be based upon firm scientific principles, which is peer-reviewed and which is also carefully scrutinized by both prosecution and defense lawyers. So how can it be possible to present an entirely erroneous case at trial? Lindy Chamberlain's case was just as bad. The brutal murder of a young baby by her own mother. Again, over 20 experts at trial supported the prosecution case. The Morling Royal Commission found that they had all made mistakes. The so-called fetal blood found in the car was actually sound deadener from under the wheel arches. It wasn't blood, it wasn't even organic. Other blood traces turned out to be residue of copper from red sand, which you find in plentiful supply in the outback. Is it possible that some allegations of criminality are so bad that we can forget our obligations to due process and rule of law and decide that we need to do what it takes to get the right answer? Clearly, they are some of the worst cases which involve deliberate falsification of evidence. The United Kingdom cases of Twitchell and Treadaway, where suspects were tortured into signing false confessions, would fall into that category, and so do the convictions of the alleged IRA bombers. But the cases of Splatt and Chamberlain almost certainly involved well-meaning experts who, in the context of an appalling crime, went a step too far in their desire to assist the prosecution. How then might we assess the wrongful conviction of Mr. Keogh? The Crown said he murdered his fiancée just weeks before their wedding. His motivation, it seemed, was that he really didn't want to get married, and he thought he could make significant sum of money from some insurances he had taken out on her life. At his trial, the jury was told there was evidence of bruises to the leg of the deceased. Those bruises were said to have been a hand grip and the one positive indication of murder. Further evidence was given to the effect that forensic evidence established that the defendant, or the deceased in this case, had been conscious when forced into the water, thereby ruling a slip and a fall accident. The Court of Appeal subsequently described some of the forensic evidence given at trial as being false and misleading. It said that the chief pathologist had misled the prosecution, the defense, the judge, and the jury. The 4 experts who gave evidence on appeal, including Professor Thomas, called by the defendants, and Dr. Lynch, called by the prosecution, said that there was no forensic evidence of a criminal assault. They were agreed that the cause of death was most likely a slip and fall accident in the bathroom, perhaps associated with circumstances that might have caused fainting, alcohol consumption, a warm bath, standing up suddenly, a cardiac or neurological defect. Tests have been conducted to show bruising, said to have been associated with the act of murder, had almost certainly occurred days, if not weeks previously. The experts were agreed that there was in fact no evidence of drowning and that the cause of death would have to be put down as undetermined. This was because the autopsy was essentially incomplete and proper testing of alternative possibilities had not been pursued. The important question for us to address is, was it necessary for Mr. Keogh to spend 20 years in prison before the court could arrive at that conclusion? The answer, of course, is clearly not. Mr. Keogh had spent nearly 6 years in prison before we set to work on his case. Within 12 months of commencing our research, in October 2001, we broadcast a program with ABC Four Corners in which many of the problems were canvassed. The inadequacy of photographs, that black and white photographs were used to suggest that there was evidence of bruising. The incorrect interpretation of tissue slides. In fact, Bob and I can still see Tony Thomas's face as he explains, "I can't see how you could possibly describe that as a bruise." And the program also raised questions about the pathologist not being properly qualified. Much of the evidence accepted by the Crown as evidence of substantial miscarriage of justice in 2014 was in fact on public record in 2001. We all know about justice delayed being justice denied. So why the delay in this case? It is now clear that 12 of the 13 years between 2001 and 2014 were taken up with procedural wranglings. None of that time was spent looking at the substance of the complaint about wrongful conviction. We went to the Court of Appeal only to be told that they could not listen to our concerns. Mr. Kiyo has already had one appeal and was not entitled to another one. They claimed that was the inevitable result of the wording of the legislation, which we thought was incorrect. The legislation merely states that a person may appeal. It does not state that they may only have one appeal. But this view of the power of the appeal court was nationally accepted and was unimpeachable. We then went to the High Court only to be told that there were technical reasons why the High Court would not admit fresh evidence showing that there was wrongful conviction. Whilst there are ways, and there have been ways, that the High Court could have worked around it by remitting the matter to the Court of Appeal, they chose not to do so. And they said, look, you do still have the petition procedure. So the only remaining option was to apply to the Attorney General through what is called the petition procedure, which is to see if the attorney could refer the case to the Court of Appeal. And that was really the only avenue through which a court could hear a further appeal. However, if an appeal was to be successful, that could lead to the potential criticisms of the prosecution, of forensic services, of the police, possibly even of the courts, all of which come within the responsibilities of the Attorney General. Hardly surprising then to find that attorneys are disinclined to refer cases to courts, even where there may be some compelling reason to do so. We also discovered that the court had said, in a South Australian case, that the attorney in considering a petition had an unfettered discretion and could refuse it for any reason or for no reason at all. That the attorney did not have to give reasons for refusing a petition, and that a refusal of a petition was not appealable to the courts. In both Canada and the United Kingdom, similar review provisions do require the giving of reasons and are subject to judicial review. We had also, with Mr. Kevin Borick QC and with Dr. Harry Harding, conducted extensive proceedings before the Medical Board and the Medical Tribunal of South Australia, which also led to other proceedings by way of review. We were able to obtain documents from the Medical Board which showed that they had been severely critical of the forensic evidence which had been given at Mr. Keogh's trial, such as failed to comply with standards which had been laid down in 1908. And here we're talking about an autopsy that was conducted in 1994. But then rather surprisingly formed the view that it had not resulted from any unprofessional conduct. So really we were stuck in a blind alley. Very detailed petitions along with extensive affidavits from leading experts for Mr. Keogh were being submitted, but they were being refused. One of the petitions took nearly 4 years to get a response. We then decided, as academics, we decided to take a different approach. With the assistance of Anne Bressington in the Legislative Council, we presented a bill to establish a Criminal Cases Review Commission similar to the one that was working and still working very well in the United Kingdom. We knew there was absolutely no chance of it being established as legislation because it would not have the government support. But we thought it was an important issue that might well stimulate some public debate. And that actually coincided with the publication of one of our books, which was launched by Anne Bressington very kindly at the Parliament House. And I think Aaron, one of our students at Flinders, was one of her research assistant then. So it's wonderful. And Aaron decided after all that time to come back to Flinders and become a fully fledged lawyer. The bill was referred by Parliament to a review committee, which then sought public submissions. As it happened, we had over the previous months pursued a complaint to the Human Rights Commission, in which we had argued that the appeal procedures which we had struggled with were inconsistent with Australia's international human rights obligations. We said that they did not guarantee the right to a fair trial or to the right to an effective appeal. It was a bold claim because the appeal rights were common across all states and territories in Australia, and they had been unchallenged and unchanged for the previous 100 years. Fortunately, the Human Rights Commission agreed with our submission and took the opportunity to send a copy of their report to the Legislative Review Committee in South Australia. The committee, having received a number of submissions, then recommended the establishment of a second right of appeal. They call it a second and further right of appeal, which would allow people claiming to be wrongly convicted to apply directly to the court for leave to appeal. Mr. John Rao, as the then Attorney General, agreed that such important decisions should not take place without public scrutiny, which legal proceedings would provide. And that is what Mr. Keogh did. His application for leave to appeal was lodged shortly after the Act for the new right of appeal came into force in May 2013. However, shortly after lodging his application, he was provided, or his lawyers were provided, with a report which had been obtained by the Solicitor General as part of an earlier petition procedure. It was a report from an independent expert. It stated that the forensic evidence given at Mr. Keogh's trial was not correct. Indeed, it canvassed many of the points which were subsequently accepted by the Court of Appeal as grounds for allowing the appeal. The disclosure of this report on Mr. Keogh's appeal was particularly problematic, partly because it ought to have been disclosed to Mr. Keogh and his lawyers when it was received by the Solicitor General many years previously. But it was also problematic because it was a significant basis upon his appeal, upon which his subsequent appeal was allowed. And those assessing the petition application 9 years earlier could possibly have appreciated that that could be the likely outcome. So that error of judgment cost Mr. Keogh another 9 years in prison. Of course, there was great relief when the conviction was finally overturned. We thought it to be most fortunate that prosecutors determined to try, unfortunate that prosecutors determined to retry Mr. Keogh when they had 4 experts saying that there was no forensic evidence of a crime having occurred. However, they maintained, as some politicians still do, that there was plenty of other circumstantial evidence which might help to secure a conviction. Some months later, the prosecution was formally terminated without going to trial. It was said that it was because the Crown pathologist was not well, and that was the reason why the case could not proceed. It should be said that if things had been done properly, then forensic evidence can be presented even when individual pathologies may through accident or infirmity be unable to appear in person. It would also be surprising if the Crown were to use the pathologist in a further trial after the previous court had determined that his evidence had been false and misleading. And there could potentially be other impediments that a defense lawyer could raise about his qualifications, etc. Now, what is clear is that the Crown's frequent assertion that there was other circumstantial evidence of guilt beyond reasonable doubt, apart from the forensic pathology evidence, turned out to be incorrect because they were clearly not willing to proceed again on that basis. As we explained in our evidence to the Parliamentary Committee, after Mr. Keogh had received his sum of money as compensation, that he was not only a free man, but he also retains the presumption of innocence, which is all any one of us has. In retrospective, it's quite shocking to think that without the intervention of the new right of appeal, Mr. Keogh would not only be in prison today, but he would remain there for the rest of his life. We still insist that as part of rehabilitation, people must acknowledge their crime and must express remorse if they are to be released after having served their non-parole period. It is not possible for an innocent person to do that, short of making a false confession. Now, I know I'm running out of time. Gary has given me some clear indication that I should not push too far, but I'd just like to sum up by saying that clearly this new right of appeal has been of some significant benefit in South Australia. It has led to the overturning of conviction in 3 cases, where otherwise appeals would have been impossible. However, a right of appeal without resources to investigate the basis of wrongful conviction, however well motivated law students and legal academics and journalists may be, it is a very, very uphill task. We clearly need a criminal review commission, such as that which exists in the United Kingdom, with the right to access files held by public and private bodies, such as prosecutors and forensic services. The right to retain experts to help with analysis of errors at trial, as happened with the Splatt and Chamberlain cases. If it is said that we cannot afford the cost of such a commission, then let's bear in mind how much it has cost us in just 2 cases, us as taxpayers, in Mr. Keogh's case and Mr. Mallard's case. We are told that it costs around $100,000 a year to keep each person like Mr. Mallard or Mr. Kiyo in prison. So over that period of time, that would be over $3 million just for the 2 of them. You add to that compensation of $3.6 million paid to Mr. Mallard, or the $2.5 to Mr. Kiyo, and their cases on a very conservative figure cost us $9 million. Enough, one might think, to run a proper review commission. Thank you.
Thank you very much, Bibi, for a really informative presentation. I was certainly very gripped by your analysis of the case and of miscarriages of justice. Thank you for that. Now, I'd now like to introduce our panel members for the evening. And they're going to discuss particular aspects of the case. They were all involved in the case. And I was talking to them before. What I was particularly impressed with was the length of time that they were involved in the case. So this wasn't something that took a weekend or a week. You know, this was years and years. And it shows their real dedication for ensuring that justice was done in this particular case. I'll start off by introducing Dr. Robert Moles of Flinders University. Please take a seat. Now, Now, Bob Moles is a legal academic and a researcher, and he's well known for his expertise and writings on legal theory and miscarriages of justice. Next, we have Professor Tony Thomas. Now, Tony is an anatomical pathologist who has worked in the UK, New Zealand, and Australia. And he's an internationally respected authority on cardiac problems and is frequently consulted in relation to sudden and unexpected deaths in young people. Third, we have Graham Archer. Now, Graham is an investigative reporter and producer who has worked for the ABC, for Channel 9, and is now Director of News and Public Affairs in South Australia for Channel 7. That's also while he was working for Channel 7, he did a lot of the work on this particular case. And finally, we've got Sam Abbott QC, who's a barrister at Bar Chambers. He's appeared in such criminal cases as Von Einem, Eugene McGee, and the Snowtown case, and also at Henry Keogh's second appeal. He's a legal officer with the Royal Australian Air Force, holding the rank of Wing Commander, and he was appointed a senior counsel in 2014. Now, I'd like to thank you all for joining us this evening and being able to share your experiences with this case and more generally with miscarriages of justice. I'm going to ask each panel member a few questions before we move on to questions that were prepared by audience members that I'll come to in a few minutes. Firstly, can I ask Tony Thomas? Now, forcible drowning was obviously a central plank in the prosecution case at the trial. Yet you gave evidence on the appeal to say that it could not be established that drowning had occurred. Can you briefly explain why you say that?
Yes. Can you all hear me? Yeah. Thanks, Jerry. I think that question has two prongs to it. The first is the need to establish the diagnosis of drowning. And the second is the need to establish that this was an assisted or homicidal drowning. I'll take the first prong first. It is well accepted in forensic practice, despite the emphasis placed on certain findings at the initial autopsy, that there are no diagnostic signs of drowning. In other words, the diagnosis of drowning at autopsy is a diagnosis of exclusion, whereby you must exclude all natural causes. Let me give you an example. A gentleman is walking along the banks of the Torrens and experiences a heart attack. Effectively, the heart stops beating, and if he's not resuscitated, he dies. Unfortunately, in this case, he slips into the River Torrens and is found floating in the river. Is that drowning? No, clearly not. It's a natural disease process that has revolved around and caused him to fall into the river. I do not believe that the initial autopsy excluded all causes of sudden natural death, of which there are a multitude. And despite what our former DPP said, that young people do not die suddenly and unexpectedly for no reason, unfortunately they do. The second prong is, even if you accept that the death was drowning, does that mean that it's an assisted or homicidal drowning? And the answer is clearly no. Let's go back to our man again walking along the Torrens. This time he doesn't have a heart attack, he slips. And he falls, and he knocks his head on a rock that gives him a large bruise on the head and a laceration. And he falls unconscious into the water. He still continues to breathe and inhales water. Is that drowning? Yes, by definition. But what caused it? It was an accidental cause, not a malicious cause. And in the autopsy again that we are concerned with, I do not believe that accidental causes or a natural event leading to submersion in the water were excluded. And they were my reasons put to the Court of Appeal and agreed on by the other expert witnesses and particularly by the prosecution witness.
Thank you. I have another question for you, Tony. The expert who advised the Solicitor General said that tests should be done to determine if hemosiderin was present within tissue samples. Could you first explain what hemosiderin is?
Yes.
And secondly, explain why would that have been important in this particular case?
Right. When we all know when we get a bruise, it changes colour from red to purple through to brown to yellow. And that's due to a breakdown of the blood cells which are extravasated or released into the tissues where they shouldn't normally be. Now, part of that breakdown is the release of iron, because blood contains iron. And in so doing, it forms a compound which is called hemosiderin. So hemosiderin is a breakdown product of blood, basically. The thing is that after a bruise, hemosiderin, and this has been shown scientifically in a number of cases and experimentally, hemosiderin does not form for at least 2 to 3 days after the initial bruising. Therefore, the finding of hemosiderin in that tissue taken from the mark, said to be the thumbprint on the left leg of the deceased, meant that any mark that was appreciated, with only black and white photos, no colour photos, any mark that was appreciated could not have occurred at the time of death, but must have occurred at least 2 to 3 and maybe weeks or months earlier. So the hemosiderin became a very pivotal point in the appeal process. I have to say, and I haven't said this to Bob or the others yet, in my mind, it was a little bit of a red herring, because if you looked at that tissue down the microscope that was said to be a bruise and indicative of a hand grip, there was no bruising there at all. So although the hemosiderin was present, that would indicate a previous trauma, some weeks, even months earlier. And if the pathologist saw a mark there at all, then it could be easily explained in that way and did not indicate a hand grip or a thumbprint.
Okay, thank you. I'd like to ask Graham Archer some questions. Under your guidance, Graham, Channel 7 had pursued the disclosure of the Solicitor General's report even after Mr. Keogh's conviction was overturned. Why did you do that, and what do you think it achieved?
Thank you. This is where I risk defamation as I open my mouth. So I'll just proceed by saying everything that I'm about to say is my opinion. When the Solicitor General's report was released, it was proudly trumpeted by the Rand government. Kevin Foley was the person who took delight in explaining that Henry was a horrible, dreadful murderer and that there was ample evidence of that, and that the Solicitor General's advice was that while there was a few errors with the pathology, there was an overwhelming body of circumstantial evidence which proved he was guilty. Firstly, in my view, it wasn't Mr. Ccrc, who was the Solicitor General's job to decide Henry's guilt or innocence. It was his job to see if there was any legal elements to the case which challenged what had been put before the court and whether those things were sufficient to go back to the appeal court. The appeal court would then make its own assessment and the proper process would follow. But Ccrc didn't do that. He decided that Henry was guilty and therefore nothing else mattered. What I wanted to know was how he arrived at that decision, and secondly, how he managed to dismiss the pathological evidence, which was compelling and I think was sufficient to have the case referred back. But of course we were knocked back. Freedom of information for a whole lot of spurious reasons was denied. And I maintained that there was a wave of privilege between the government and Ccrc on the basis that the government had chosen to release a lot of his advice, and therefore you can't pick out and cherry pick bits. You either keep it confidential or you release the lot in the interests of fairness. Almost 10 years passed. In fact, less than that, 6 years passed, and Mari Shaw and Sam came on board, and they organised a meeting with the new Solicitor General. By this stage, Mr Ccrc had been rewarded for his work with the government and was now the full court, the Chief Justice of the Supreme Court. So when the Vernon Roberts report came out, it made references to the fact that this was almost certainly an accidental death, and that, as Tony has said, made reference to this possibility of hemosiderin being found in the bruises, which would prove that they were historical and not made at the time of death. And it became clear that Vernon Roberts, who was the state's probably most senior pathologist at the time, had urged Mr Ccrc to undertake this test. And we're talking 2004. So by now, that was 10 years ago. There were not just references to it in Vernon Roberts' report, but he'd written letters to Ccrc saying, I think this is important, but you need to authorise it because I don't know who's in charge of the tissue samples which remain. So I went back to our freedom of information and thought, well, I wonder what Mr Ccrc made of hemosiderin. I mean, how did he get around that, or did he conduct a test? So we began what became a very lengthy legal process to get freedom of information access to his advice. It was knocked back time and time again. We ended up with the Ombudsman. The Ombudsman decided we should have it. The government refused, appealed. We ended up with the full court of the Victorian Supreme Court acting as auxiliary judges, and they found in our favour. They said, yes, you should be entitled to look at the advice. Privileges have been waived and you should have it. Of course, this cost probably Channel 7 a huge amount of money because we had to go through the appeal process and so on. It's probably a couple $100,000 just to get this document. It was released and there's not one mention of hemosiderin in the document. Now, there was a lot of information about why Mr Ccrc thought Henry was an evil murderer. There's not one word about hemosiderin. Now, when you think about this, he's now the Chief Justice of this state. His own full court in the appeal says in its judgment, and I quote as accurately as I can, that the presence of hemosiderin undermined Dr Manic's mechanism of murder. Now, in a simple sentence, that's how powerful this a test for this chemical was. Now, you can't tell me that Mr Ccrc made an error in going, oh, I forgot to get the test done. He understood the significance of it, and it was deliberately not conducted. I mean, the fact that it's not in his advice indicates that there was he mentions Vernon Roberts' report, gives it a page or two, but he doesn't mention hemosiderin because it was the uncomfortable truth that they didn't want. It was made very clear to him by statements that Rann and Atkinson had made publicly for years that this case was never going to find its way back to the Supreme Court. And that's what was revealed. Can I get anyone else in the media interested in the significance of that? So far, no. I'm not in a position to do it because I have actually retired. But there you go. I think it was very important.
Okay, thank you. Another question, Graham. Some lawyers think that their clients should stay away from the media when protesting their innocence. Now, clearly, the Attorney General of South Australia was not impressed by Channel 7's rule in this particular case. So looking back on it, do you reckon that your role and Channel 7's role helped or hindered Mr. Keogh's appeal?
Well, I hope it helped. It may have prolonged it by making more enemies than we needed to, but that was never our intention. Look, you know, lawyers, of course, have to work within the system that exists, and they will give their clients advice to stay away from the media for obvious reasons. I mean, there are issues of contempt and so on. Once they have been convicted, of course, well, you know, they're set adrift. And it's a very risky business for the media to go out on a limb on a case that has been through all of the court and appeal processes. It's risky because, firstly, we don't have the power to subpoena and demand documents from police, from the DPP, from all those privileged sources. So you have to rely on what's already out there. It's risky because you will tread on some fairly sensitive toes, and defamation is a real hazard. And we fought a case for 7 years against Dr. Manic, in which we were accused by the Supreme Court in the end that we were deep-pocketing Dr. Manic. We were denied the right to plead truth in our appeal, in our defence. The irony is that Dr. Manic was being funded by the South Australian government. So if anyone was being deep-pocketed, it was Channel 7, and those 7 years cost about $2 million. And they were unrecoverable. So, you know, there are big risks for the media, but I think they have a role to play. I think, you know, you've got to choose your cases because there has to be the potential for evidence that will challenge what was put to the court. You can't just go out on a limb without understanding where this might lead. But certainly Henry's case was one such case, and hopefully with the change of legislation, which I think is the main legacy of this whole exercise, we played a positive role.
Okay, thank you.
Sorry, could I just make one comment that I said that I thought the hemosiderin was a little bit of a red herring. I meant that from a pathological point of view only. As Graham has pointed out, from a legal aspect, it was vital.
Okay, thank you. A couple of questions for Sam Abbott, QC. The Court of Appeal was not impressed when you attempted to provide the judges with copies of the coronial baby deaths report on Mr. Keogh's appeal. How did that relate to Mr. Keogh's case?
Could I just start by making one observation before I deal with your question?
Sure.
And that is this. In my view, that Mr. Keogh was one of the most unlucky people going around to have suffered the outrageous miscarriage of justice that he did because of the conduct of Dr. Manic. But he was almost equally lucky to have Mr. Archer go into bat for him for something like 15 years. And there is nothing more certain in my mind than the fact that he would not be out here today were it not for that man there.
One of a number.
You're a pretty big one though, and it was and your television station, who also should be praised for committing so much money, but it was their involvement that brought along the momentum that resulted in the change in the legislation, which was so crucial, and the change in the legislation was supported so well by the two academics to my right. But anyway, back onto your question. Some background to that. In the course of the appeal, we deployed a very, very large number of expert reports and new evidence and fresh evidence that we said supported our case. One category of evidence that we sought to put before the court was information concerning prior conduct by Dr. Manic in earlier cases, not related in any way to Mr. Keogh. And they're colloquially, or some of them are colloquially called the baby deaths cases, because there was a coronial inquest into a number of deaths that Dr. Manic had conducted autopsies about concerning early baby deaths, and the coroner came to the view that he had been entirely negligent in his conduct of those inquests, sometimes missing clear evidence of wrongful conduct by fathers or stepfathers and the like, and sometimes committing other errors. And so we sought to put that evidence before the full court to show that the state was well on notice prior to deploying Dr. Manic as its expert witness in the trial, and so that was another string to our bow to say that this case had miscarried. I was not dismayed in my own mind. I didn't tell too many people this at the time, but I wasn't dismayed when the full court knocked me back, because they said, "What do you need that for? You don't need that evidence. We are concentrating on what Dr. Manic's performance was in this case. Whether he made errors in other cases is not really to the point." And I was strategically quite happy with that, because I thought that at that stage, if they don't need that evidence, then we're looking pretty good in terms of the outcome of the appeal. So, and that happens sometimes in court. If the judge knocks you back on something, it might well be because he or she's already with you. And so I was not too dismayed about the fact that they knocked me back. But that doesn't mean to say that it wasn't evidence of his prior poor performance.
Okay, thank you. And another question, what's your view about the role of the media in potential miscarriage of justice cases?
Perhaps just or answer that already. It is important for the reasons that Graham has already given you, and there have been media involvement in some efforts to overturn convictions in the past in this state, not least of which was from the Advertiser many years ago. It is important for the reasons that Graham said, in that the lawyers have a constrained set of parameters in which they must work. They have ethical obligations and rules of court and the like. And there are certain things that need or should be done to motivate a sway in public opinion, for example, or to motivate an incentive in the parliamentarians to do something about this. And that's not something that lawyers can do or should be doing. They should be getting on, looking at the case and trying to work out how to run the appeal. So, in my view, it's a vital cog in the wheel to get that support. And as you've already heard, you heard how important I thought it was in the whole thing.
Okay, thank you very much.
Stewart Coburn did it many years ago in relation to another case.
Thank you. And Bob Moles, you've publicly stated that there were some serious non-disclosures by the Crown in Mr. Keogh's case. Can you briefly give us some examples of what you have in mind?
There are quite a number of issues that were of grave concern to us as the academics who are providing the background to our understanding of the case. They really fall into two categories. One is the other cases in which Dr. Manic was involved, and in which he had made what we regarded as fairly serious and egregious errors. We don't have time to go into all of them now, but I'll just mention one or two small things, if I may. There was a case called Gerald Warren, which involved the death of a young Aboriginal boy who's found on a dirt track outside Port Augusta. Dr. Manic had initially said that the young boy had died by falling out of a moving vehicle, and that when he had a couple of injuries to the back of his hand and his face, and there were some parallel marks in it, that in fact those injuries were caused by the fabric of corduroy, his trousers, as they came into contact with him as he fell out of the moving vehicle. It subsequently turned out that in fact he'd been beaten with a scaffolding pipe and then had a car run backwards and forwards over the top of him. And so he issued another report that was consistent with that story. So in the hearing of the trial, it goes a bit like this. Dr. Manic, you said initially that those injuries were caused by the fabric of corduroy, yes, but now I believe you say that they were caused by the threaded end of a metal pipe which struck him, yes. Is that not a little contradictory? No, said Dr. Manic, because if you impress the fabric of corduroy against the skin on the one hand, or strike it with the threaded end of a metal pipe on the other hand, the injuries would look indistinguishable at autopsy. It just doesn't make sense. Well, Dr. Manic, you initially said that he'd fallen out of a moving vehicle, yes, but now I understand you to say that the vehicle was actually driven backwards and forwards over the top of his body several times, yes. Well, isn't that contradictory? No, said Dr. Manic. In either scenario, the physical forces are very similar and the injuries would be indistinguishable at autopsy. Now, I just don't believe that, and I've never come across anybody else that believes that, but it's on the record, and the interesting thing for me is that no questions were asked about that during the course of a trial. So you've got 2 QCs, 2 junior barristers, 2 solicitors and a judge listening to this, and apparently it all goes through. Or, in that case, you've got a coronial inquiry. In the other case, you've got a coronial inquiry. But you've got lawyers listening to this. The other case is Terry Akratides, who was supposed to have fallen off a high tower, hit the roof of a building, landed on the ground. Dr. Manic said that we know he's fallen off the high tower because there's a hole in the roof of the adjacent building, which was caused by the impact of his body. It was a thick concrete roof, 2.5 inches thick, 3/4 inch reinforcing bars running through it and a 3-inch mesh. The body, according to Dr. Manic, hit the roof, knocked a hole in it and bounced onto the ground. Are there any serious external injuries on the body? No. Are you surprised at that? No. And why aren't you surprised at that? Well, because his clothing was interposed between his body and the surface that it struck, and that's why he didn't have any serious external injuries. And in relation just quickly to the time of death, Dr. Manic informed the coroner's court that he placed the time of death 12 hours before the body was undressed at the autopsy. That happened to be 2.5 hours after the police found his dead body, already stiff with rigor mortis. So according to Dr. Manic, he died 2.5 hours after the police found his dead body, which makes no sense at all. And this is all on the record. The other couple of things that are important, in the mid-1970s, Dr. Manic was before the courts in a civil action with his employer, the Forensic Science Centre. And during the course of that civil action, the head of the Forensic Science Centre said, look, we have to change Dr. Manic's works arrangements for 2 reasons. The first is he's actually not qualified to certify cause of death, which is obviously quite an important deficit if you're a forensic pathologist. And the other one is he has no expert qualifications, even though he is in an expert's position, which actually means he's not entitled to give expert evidence in court as an expert witness. So the state of and he never improved his qualifications after that. So the state of Australia has to explain why it is that they allowed him to give evidence and secure 400 criminal convictions when he actually wasn't allowed to appear in court as an expert witness at all, and why they allowed him to do 10,000 autopsies when he was never actually qualified to certify cause of death. And that problem's never been addressed. So we have a couple of difficulties there, if you see what I mean.
Absolutely, yeah. Following on from that, one of the things that Bibi raised in her presentation was that the new right of appeal should be supplemented by a criminal review commission. Now, Bibi pointed out that there may be good fiscal reasons why there should be a new criminal review commission. But I was wondering if you could outline some other benefits of such a commission other than just those to the taxpayer.
When a person goes to prison after they've had a criminal trial and an unsuccessful appeal, even if they had some money before that, they were very unlikely to have any money after that. So if you take the position of a person who's in prison and they know that they're wrongly convicted because they didn't do it, what they have to try and do is to find proper grounds that they can put to a court of appeal to establish that. Picture this, if you will. You're in a prison cell and you want to look at the transcript of your trial and the transcript of your appeal. You're only allowed 50 pages in your cell to have a look at. So you have to say, well, let me have a look at pages 750 to 800. That may or may not be the 50 pages that you want. So if you get that, and it's not the 50 pages that you want, you have to hand them back and say, well, maybe it's 800 to 850. And it takes days, sometimes weeks to get access. How could you possibly run an analysis of the transcript of anything by guessing at bits that you may want and without any assistance? And then you have to try and think about, well, what sort of expert evidence could I have? When we were outside, Bibi and I, we had the great privilege of being able to talk to people like Tony Thomas. If I could begin to describe to you the number of experts, both around Australia and overseas, who came to our assistance to assist with Mr. Keogh's appeal, I could spend a whole evening going through the people who assisted us. Professor Pounder came from the UK on one occasion to have a look at the evidence that we were intending to put forward on the appeal. And then he came back just a few weeks later to actually give evidence at the appeal. That he wasn't being paid any great sums of money for the time that he spent. He was in his retirement. His wife was actually ill at the time. And the reason he did that, because he actually thought it was important. He really wanted to help. He wanted to sort out the issues involved in that case. We could assist in some way to coordinate the people who were needed to come together to assist Mr. Keogh's appeal. If Mr. Keogh didn't have us as a team and was trying to work on his own to present an appeal, it would be impossible. If you had a Criminal Cases Review Commission, it would be entirely different. You'd have funding from central government. You would have a team of people. The Ccrc has roughly a team of 60 people. They have 6 people working together on each team to review the cases. They have a statutory right of access to go to the DPP's office, to the police, to the forensic services. And as the head of the Ccrc said once, we can walk into MI5 and MI6 and look at their files as well. We can access any information we want to discover non-disclosed material. We can hire the experts. We can get the job done. And it's important to note that of all the cases that go to the Ccrc, only 4% end up getting referred back to the courts. So 96% don't make the cut. But the 4% that do represent 420 convictions that were overturned in roughly the same time it took us to overturn one conviction here in South Australia. And when you look at the David Eastman case, where they had a major inquiry in order to overturn his conviction after about 20 years, that alone cost $12 million. And you could run a whole Ccrc for several states on that for a long time. So the benefits of a Ccrc are social benefits, economic benefits, benefits all round, really.
Okay, thank you very much. We've had some questions from people in the audience, which they gave on the way in. And I'm just going to give them to all the panel members. Please feel free to choose who you can all answer them. Firstly, what advice do you have for someone who believes they've been wrongly convicted or has received an unjust court ruling?
That'd be me then. At least I don't cost anything. Well, I think, that is part of the role of the media. And, someone in prison obviously requires people on the outside to speak for them. I think that they should contact the media. I don't know these days who that might be, I have to say. There's a diminishing number of organisations who want to invest in this kind of stuff. And really it involves individual journalists who have a personal sort of commitment to it. I mean, you know, there are some, and these days, you know, the broadcasting landscape has changed, and there are podcasts and a different way of presenting this material. I'm not sure how effective that necessarily is. Once again, you need a powerful organisation like News Corporation behind you. But the first step is to gather together the information that has been collected during the process. It's absolutely vital that that material preferably is preserved along the way. I've been helping someone whose son is facing an attempted murder case, which is very peculiar. And I've said to her, get everything. Don't trust anybody to keep the material and hand it to you afterwards. Get it now and get copies of it, because it will disappear. And if you get the judgment you don't want, the only hope you've got is that you've got all of the material that you could possibly collect that relates to the case. And look, there are some cases that, and I won't go on, but there's some cases where the smoking gun is impossible to find. It might be there, but it's not something anyone can find. The process was miscarried from the beginning. The right questions weren't asked. The right people weren't consulted, and the opportunity is lost. Unfortunately, you know, that's a reality. But, you know, it all depends on gathering the information and making sure you've got a cogent and complete, you know, copy of everything that's related to those cases.
Could I just add quickly there that when Sam first asked us to have a look at a case, so Henry Keogh's case, the only reason I said yes was because I didn't know what I was doing. And if I had known what it involved, I would certainly have said no. I said something fairly naive, like, well, look, there's some evidence about a wrongful conviction. Let's have a look at it and we'll have a look through it. I can still remember somebody coming up the corridor in the law school with a wheelbarrow with a whole bundle of files in it. And apparently that was just a small sample of what they had to look at. Reviewing a potential case of wrongful conviction is an enormous task. And just one small point I'd like to make, and in a sense put the question back on you, it's an ethical problem. Every week or every month, I get brown paper envelopes coming through the post, and I can tell how desperate the person is, usually by looking at the title on the front of the envelope. If it starts off Dr. Professor Sir Robert Moles, I know they're really very desperate. And when I open the envelope, if I find foolscap pages neatly handwritten and they exceed 20 pages, I know the person's very, very desperate. But the question then is, what do I or what do we do? I can't even begin to have a look at a case without having all of the other materials available, and they're not going to be available. I've just got what this person says. Now, do I write back to the person and say, look, I'm sorry, I can't help you, that's the end of that, because that would be devastating, I suppose, for them. I mean, clearly, I'm the last port of call. If they had any sensible person to write to, they would have done that first, wouldn't they? Or do you not reply at all, in which case that seems unkind as well, doesn't it? So I must admit, I'm not quite sure how to resolve that dilemma, even yet, but you're welcome to come and see my pile of brown envelopes at any time if you'd like to, because they're very big and there's a lot of people in that situation.
Okay. Another question. This was partially answered, I think, by Graham a few minutes ago. But other people may want to add something here. Who or what organisations gave financial support for the appeal of the Henry Keogh case?
That's something we're often asked about, because people frequently say things like, during Mr. Keogh's period of imprisonment, there was a big truck parked up on the freeway, and Henry Keogh's family must have a lot of money to keep that going. and there was that other truck that was going around the town with signs on it and things like that, they always said, oh gosh, that's the Keogh family again, they must have lots of money. There were an enormous number of experts and lawyers and all sorts of other people involved over a period of 20 years. I can confidently say that from my knowledge, apart from John Lewis, who was the owner of a business in town and who used to be able to put in some sums of money to assist with lodging and filing fees for applications to the various courts and things like that, which was essential. The whole thing was run without any money at all. You would be absolutely astonished to find the number of people like Tony Thomas who put in thousands of hours over the 20 years for absolutely no money at all. Professor Pounder, there's 20 or 30 experts that worked with us for absolutely no remuneration. And most of the legal work that was done entirely without any remuneration either. And the lovely thing is that the right people always seem to appear at the right time. People often talk about, well, what's network knowledge? What sort of an organisation is that can pull all these people together? It was a series of serendipitous chances. It was fate. It was good fortune that actually happened at the right time. So you actually have to believe in the possibility of doing things without any resources to even get started. And it worked. I'm going to have to correct Bob there a little bit. No, get your hands off. In that, at the medical tribunal, I think it's 2009? Yes. 2008, I was actually called by the medical board itself to be a witness.
2009, Tony.
2009, thank you. So correct Bibi as well. Right, okay. I was called to give evidence to the tribunal about the case and about the findings of Dr. Manic, etc. I was absolutely castigated by Judge Clayton, who called me biased and untrustworthy. So I thought, I'm going to put in a bill to the medical board. And I got a few thousand.
The other problem with funding is that the Legal Services Commission is so poorly funded. So even if you have, as we did, an indigent client who had been in jail for so long, the Legal Services Commission is not willing to fund you if you want to either investigate or even at the stage where you've carried out your investigations, you think there's a reasonable prospects of success of getting leave to appeal. The Legal Services Commission in this case didn't fund the application for permission to appeal. Now that was a hearing that went on for a large number of days, and it required an enormous amount of work because it required us to prepare the entire appeal for the purposes of getting permission to appeal. And we asked for, but were not back for funding then. And it was only after we received permission to appeal, in other words, when Justice Nicholson, the single judge who considered the permission application, had determined that there were reasonable prospects and we should be given permission to appeal. It was only after that had occurred that we received funding from the Legal Services Commission. So even with the opinion of 2 Silk provided to the Legal Services Commission prior to the permission stage, we still didn't get funding. So that's how scarce legal services resources are in this area.
And I can say that Murray, Shaw and Sam, when they took it on, knew that the prospect of getting paid was pretty well negligible. And look, you've got people who have got businesses to run effectively. These are hours that they could be billing for other clients. And so, you know, it's an unknown quantity of time that you're committing. And the 2 firms that provided support with solicitors, they did so pro bono. So, you know, it's a big contribution and one that, you know, we should be grateful that people with such terrific qualifications but also skills were willing to take on. I mean, in terms of money, the Kiyo cost Channel 7 a huge amount of money, none of which went to Henry. So there was, costs all along that have to be borne by those people who are involved. And, Murray and Sam just took that on, knowing that effectively it's a blank cheque of time that they're signing.
Could I just add quickly that there is actually a lot of scope for university-based innocence projects to do more. We have over 30,000 law students in training, or at least we did when I was at the university. It's probably greatly in excess of that now, but let's just say 30,000 law students in training, and if only a small percentage of those were actually part of university-based innocence projects, the students could learn a lot from it, and they could actually benefit very considerably the ability of practicing lawyers to then actually take on a case and know that they weren't going to shoulder the whole burden. A lot of potential there.
Thank you. There's another question which I think the relevance of which was referred to both by Bibi in her presentation and also by Tony when they referred to black and white photos being taken of bruises. And the question relates to technology. Have things moved on in the last 20 or so years such that miscarriages of justice are less likely now than before? Anybody?
Shall I go on the photographs? It was said at the medical board by a prosecution witness who was a forensic pathologist from Leeds in London that at that time in 1994, it was not routine to take colour photography of the autopsy, etc., etc. Then conceded that whilst he as a professor in Leeds may have done it, little old Adelaide was not capable of colour photography. Now, I immigrated to Australia in 1986, and we were taking colour photography at St George's in London in 1973. And I think all of you realise that colour photography was freely available at that time. And strangely enough, I still have a colour photograph taken of an autopsy 2 to 3 years before the one we're considering, where Dr. Manic himself is in the picture.
As with many things, the answer is both yes and no, I think. Because we've got advances in technology that can assist in achieving the right answer and achieve in finding out the truth, but also there are things that can go wrong, and we have a tendency to assume with greater technology that the technology is right, and that's not necessarily the case. Everyone assumes when you have DNA in a case, oh, well, that's cut and dried, then you've got DNA, so be it. But we know from lots of the Innocence Project cases and from other experiences that just because you have this very, very powerful, hugely powerful technology that can go right, but it can also go wrong, and it can clothe error rather than expose it.
I suppose the simple answer is that I think what Bibi was saying in her lecture really was that the real problem with miscarriages of justice is actually the psychological issues in the minds of the investigators and prosecutors as they're looking into the cases. And if you jump to a conclusion, if you have tunnel vision, if you have elements of noble cause corruption, that's got nothing to do with the technology. That's got to do with the attitudes of the people who are doing the investigations and where they desire either to secure a conviction when they are personally convinced that somebody's done it but may not have the evidence to quite match up to that, and then they want to kind of jiggle it a little bit to make sure it's right. That's not a technological question, that's a sociological, psychological question. And I fear that as we look around the various different countries, as we do in our comparative miscarriages of justice, they're not becoming fewer. They're probably becoming greater as a problem. But certainly in Australia, we haven't begun to develop the institutional responses that are required to actually push back against that. So that although we have a new right of appeal, in the recent Bromley decision in the appeal court here in South Australia, we got a decision from the appeal court that I think is entirely inappropriate, but I think it reflects perhaps the concerns of judges about, well, what might happen if we actually broaden out this appeal right, if we overturn the conviction of Henry Keogh, that's bad enough, he's been in prison for 20 years. If we overturn the conviction of Mr. Bromley, he's an Aboriginal man, he's been in prison for 35 years, what a scandal that will be. And that may be, psychologically, whether overtly or subconsciously, might encourage the judges to say, look, we think he's probably guilty anyway, so so you have this psychological problem running through from the investigators in the very early stages, through the prosecutors who persist with, as they did in Mr. Keogh's case, saying we're going to prosecute him again, even though we thought we had no evidence, and sometimes into the judiciary as well, because they've been notoriously reluctant to recognise cases as being miscarriages of justice. So I think we all need to take a deep breath and actually have a look at retraining in each of these areas, and it's actually got nothing to do with the technology at all. Could I just take up a point that Sam made about DNA and the importance in knowing how to interpret that? I'll just say that there's an excellent book entitled Calculating Risk by a American guy called Gerd Gigerenzer, Girenzer. Fantastic little book that actually tells you about the flaws of DNA interpretation, which is so vital in these cases. Experts get up in court and say, it's a 3,000 to 1 chance it's anyone else. How many people are in Australia? And you work out that. That means, even if it's a 1 in a million chance, that means there's 22 people out there or 25 people out there who could have done it. And it's a very good book. I lent 2 of my copies to Bob and I've never got them back.
All right, just one final question for the audience before we wrap up. There are often cases where somebody who's convicted of murder is acquitted, and as Bibi pointed out, there was still a murder, and nobody has been convicted of that murder, and sometimes it's years later. Can you talk about what happens in those cases in your experience? Does it get prosecuted? Does it get dropped?
I think the one case, I think it's back on, yeah. The one case that was clearly a murder was the case involving Mr. Mallard, the woman who was attacked and assaulted and murdered in her jewelry shop was clearly a murder victim. The wrong person was charged, wrong person was convicted and spent 10 years in prison. To this day, nobody else has actually been convicted of that murder, although the police later on, after the Crime and Corruption Commission inquiry was held, police much later said that when they did some cold case review, they think somebody who's already serving a prison sentence might have done it. But that's cold comfort to the victim's family. So yes, there have been cases, and certainly in the baby deaths cases, the inquiry that was held into the young babies that died, if some were not homicidal, there were cases of gross negligence, and yet nobody was made accountable. So yes, miscarriages of justice works both ways. People who are wrongly convicted, as well as serious crime has taken place and nobody is convicted.
Jerry, I think it's important also, Bibi, to point out that in Henry Keogh's case, there is absolutely no evidence from a pathological point of view that a homicide took place. And that's, I think, extremely important, because there's a lot of public out there who think, well, if he didn't do it, who did? It wasn't a murder.
Okay, on that note, I think we'll wrap up for this evening. It's just 7:30. So I'd like you to join me in thanking particularly Bibi, but also the other panel members for a really interesting discussion. And as a token of our appreciation, we've got very small gifts for the panel.
Oh, thank you.
To enjoy afterwards.
Thank you very much. Thank you.
We'll have a raffle at the next Brave lecture. So thank you very much for coming and for attending tonight's Brave lecture. I hope you found it informative and interesting. And please keep an eye open for the next Brave lecture, which will be happening soon. Thank you.